Yes, ma'am. Water. All right. Thank you, ma'am. Just a reminder, you're still under oath, okay?
Of course, Your Honor.
Thank you.
Thank you.
All right, your question?
Amber, just to orient you and the jury, at this time, we are in the rebuttal to your counterclaim against Mr. Depp. So I'm going to confine my questions to that, okay?
All right.
How have you suffered publicly as a result of the Depp-Waldman statements?
Objection, speculation.
Overruled.
I am harassed, humiliated, threatened every single day. Even just walking into this courtroom, sitting here in front of the world, having the worst parts of my life, things I've lived through, used to humiliate me. People want to kill me, and they tell me so every day. People want to put my baby in the microwave, and they tell me that. Johnny threatened, promised me that if I ever left him, he'd make me think of him every single day that I lived.
Objection, Your Honor, non-responsive.
All right. I'll sustain the objection as to that. If you want to ask the question.
Amber, how did Mr. Depp's statements and threats to you that you were discussing, how do those continue to manifest themselves today?
In the harassment and the humiliation, the campaign against me that's echoed every single day on social media and now in front of cameras in this room. Every single day I have to relive the trauma. My hands shake. I wake up screaming. I have to live with the trauma and the damage done to me. My friends have to live with a set of unspoken rules about how to not scare me.
Objection, hearsay.
Yes, sir.
Unspoken rules
Overruled. Go ahead.
about how to not touch me, not to surprise me. My intimate partners have rules about how they can deal with me, how they can touch me. I have rules for doctors and medical professionals I see, gynecologists I see. I live my life with these sets of rules that I have to follow, my friends have to follow for me not to have a panic attack or a triggering event where I relive the trauma. Even if I'm training to do my movie, for instance, if I'm training for Aquaman, a combat scene and a trigger happens, I have a meltdown and have to deal with that. The crew I work with have to deal with that because of the damage I walk around with every single day from what I've lived through, from what I've survived. I'm not sitting in this courtroom snickering. I'm not sitting in this courtroom laughing, smiling, and making snide jokes. I'm not. This is horrible. This is painful. And this is humiliating for any human being to go through. And perhaps it's easy to forget that, but I'm a human being. And even though Johnny promised that I deserve this and promised he'd do this, I don't deserve this. I want to move on. The statements, the attacks on me, the campaign, that Johnny has elicited millions of people to do on his behalf when he himself
Objection, Your Honor,
couldn't do
lack
it.
of foundation.
Torture me every day.
Speculation.
I'll sustain the objection. Next question.
Amber, how have the Depp-Waldman statements impacted your ability to do charitable work?
You know, the only reason that people like Dr. Curry can sit up here on the stand and say I'm high functioning and I do things like have hobbies and have interests is
Objection,
because
non-responsive.
Your Honor, Mr. Depp gave long-winded responses yesterday.
Overruled. Go ahead.
It's because I found a solution to that pain. I woke up every morning with panic attacks and trauma until I realized I could do something with it. So to answer your question, Ben, I was able to turn the things that I've lived through, my pain, my life experiences, into work, into action, into providing a voice for other people. I'm not a saint. I'm not trying to present myself as one, as you all know, but I selfishly found relief in being able to use what I've lived through to advocate for others, to bring light to these issues, to give a voice to people who don't have the voice and the platform that I have. And while I would not wish this situation on my worst enemy, if it gives a voice to someone who doesn't have it. But I now, as I stand here today, can't have a career. I can't even have people associate with me because of the threats and the attacks that they have to endure.
Objection,
when they
non-responsive.
are. And I can't do my charity work.
Sustain the objection.
Amber, other than the threats that you've described, what other threats have you endured since the Depp Waldman statements were made?
I receive hundreds of death threats regularly, if not daily. Thousands since this trial has started. People mocking my testimony about being assaulted. Making fun of my...
Objection, relevance. Non-responsive.
Goes to damages. You can continue.
It's been agonizing, painful, and the most humiliating thing I've ever had to go through. I hope no one ever has to go through something like this. I just want Johnny to leave me alone. I just want him to leave me alone. I've said that for years now, and I thought he would after 2020.
Objection, non-responsive.
All right, I'll sustain the objection. Next question.
What do you hope to reclaim after this is over?
Protecting the secret that I did for as long as I did has taken enough of my voice. Johnny has taken enough of my voice. I have the right to tell my story. I have the right to say what happened to me. I have the right to my voice and my name. He took it long enough. I have a right as an American to talk about what happened to me, to own my story and my truth. I have that right. I hope to get my voice back. It's all I want. And I've said that from day one.
Thank you, Amber. I don't have anything else.
All right, cross-examination.
Actually, Your Honor, may we approach very
Yes,
briefly?
yes. Yeah.
Ms. Heard, you just testified that this case has been very hard for you. So let's talk about that and why.
All right.
Your lies have been exposed to the world multiple times, right?
I haven't lied about anything I've been here to say.
You sat here and told this jury that the events in Hicksville started with Mr. Depp getting really upset about a woman leaning on you. Is that correct?
Yes, that's effectively what happened, yeah.
You testified that he actually grabbed that woman's wrist and twisted it, right?
And told her that he could effectively break her wrist by saying he knew how many pounds of pressure, or asking her how many pounds of pressure it took to break a human wrist.
But your own witness, your former best friend, Rocky Pennington, she didn't corroborate that, did she?
I'm not quite sure what part of that night she saw. There were a lot of people there.
She didn't testify that Mr. Depp grabbed anyone's wrist in Hicksville.
Again, I don't know what Rocky saw. There were a lot of people there that night.
You testified that once you brought Mr. Depp back to your trailer, he trashed it, correct?
That is correct.
And the manager of the Hicksville trailer park was furious that Johnny had wrecked the whole thing. Do you remember that testimony?
That's correct.
Well, we heard from that manager of the Hicksville trailer park, Morgan Knight, on Monday, didn't we?
I'm not quite sure who that guy was or if he had any involvement in this. I know a lot of people have come out of the woodwork to be involved.
So you're accusing Mr. Knight of testifying and committing perjury?
I'm not accusing anyone. I just don't recognize that man.
You heard Mr. Knight testify that it was actually you who was upset with Mr. Depp spending time away from him. Isn't that correct?
How would he know? He wasn't there.
You heard Mr. Knight testify that it was actually you who was yelling at Mr. Depp.
Again, I've heard a lot of people say a lot of things to be involved in the Johnny Depp show, but he wasn't there. He doesn't know. And he certainly doesn't know what happened behind closed doors, like most people.
So you're calling Mr. Knight a liar?
I am saying he wasn't there, and what he testified to doesn't match what I know happened. But I don't fault him. He wasn't there, so how would he know?
He testified he was there, Ms. Heard. Did you hear that?
That's his testimony, yes.
So you're calling him a liar?
I'm just saying he wasn't there.
You heard Mr. Knight testify that the trailer wasn't trashed, and that's why you're calling him a liar.
He testified that a light fixture was broken, similar to the way that
yes,
Johnny's
other than a light
employees
fixture, that was
testified
the
to
only
my
thing that was
closet
broken,
being rearranged
right?
and things
Ms.
like
Heard,
that.
The only thing that was broken in the trailer, according to Mr. Knight, was a light fixture. Yes or no?
I realized that he summed it up by saying a light fixture was broken, just the way his security guard summed up him trashing my closet as being rearranged.
Your Honor, I'm going to move to strike everything after he summed it up, that it was a light fixture, as non-responsive.
She answered the question, Your Honor.
Overruled.
In the security guard testimony, Your Honor?
I'll allow it. Go ahead.
Mr. Knight also testified that he charged Mr. Depp only $62 for the damaged light fixture. You heard that, correct?
I did.
In Hicksville, you were the only one that was jealous that Mr. Depp was spending time from other people. Isn't that correct, Ms. Heard?
That is incorrect.
In Hicksville, you were the one who was upset that Mr. Depp wasn't giving you enough attention.
Incorrect again.
Ms. Heard, you told this jury that you had no idea the press was going to be at the courthouse when you got your TRO on May 27th, 2016. Do you remember that testimony?
I said I did not have anything to do with it. Yes.
No. My question again. You told this jury that you had no idea that the press was going to be outside after you got the ex-party TRO on May 27th, 2016. Do you remember that testimony?
I apologize. I must have misunderstood, Ms. Vasquez. I actually had no idea whether they were going to be there or not. When I walked into the courtroom that day, it was completely quiet, still, empty. Even though I had given Johnny's team notice that I was filing the TRO,
Your Honor, this is not
we had no reason to believe the press knew.
And Your Honor, I would also ask that you instruct the witness to please stop talking once I lodge an objection.
Your Honor, she's trying to answer the question as best she can, and Ms. Vasquez is misrepresenting to her what she testified to.
Well, I'll strike the last part as non-responsive.
Thank you.
Just if you could just answer the questions asked. Okay? Thank you, Ms. Heard.
In fact, you testified that you were, quote, shocked when you saw press when you were leaving the courthouse. Yes?
Yes.
You weren't shocked at all, though, were you?
Incorrect. It was
You knew the
horrifying.
press would be at the courthouse, right, Ms. Heard?
No.
Well, you did bring your publicist to the courthouse with you on May 27th, 2016, didn't you?
I sure did. I'm a public figure. I brought my publicist in case it blew up. in case.
You actually had alerted TMZ that you would be filing a TRO against Mr. Depp that very day, didn't you?
No, I did not.
The one day you didn't bother to wear makeup to cover up the mark on your face.
I did not call TMZ or any other news source or paparazzi source. No one.
Well,
I never did that.
Testimony from former TMZ employee Morgan Tremaine yesterday, correct?
Did I hear his testimony?
Yes.
Yes, I was here.
Yes. And you heard Mr. Tremaine's testimony that he knew to dispatch the paparazzi to the courthouse on May 27th, right?
I heard him say that he knew that, yes.
Yeah, and that he dispatched paparazzi to the courthouse to capture a picture of an alleged bruise on the right side of your face. Do you remember him saying that?
I remember him saying that.
That information must have come from your team, right, Ms. Heard?
Absolutely not. Why would I want that? What actual survivor of domestic violence wants that?
Now, the video of Mr. Depp beating up some kitchen cabinets, you admit that you took that video, correct?
Yes, I did.
Right. And you acknowledge that the video was released online the day before you were deposed in connection with your divorce from Mr. Depp in August of 2016, right?
I believe it was, yes.
But you testified that you had absolutely nothing to do with the video's release, right?
Absolutely not.
And you testified that you learned about it when you landed after flying into LA. Do you remember that testimony?
Upon touchdown is when I was alerted to the video's existence
You heard Mr.
online.
Tremaine testify that about this video as well yesterday, didn't you?
Yes, I did.
And you heard Mr. Tremaine testify that TMZ received the cabinet video the same day you landed at LAX, yes?
I don't know if that's what his testimony was. I'm sorry.
You heard Mr. Tremaine testify that the cabinet video was posted 15 minutes after TMZ received it, yes?
That's what I heard him say.
And that this could only have been possible if the video was received directly from the source, yes?
I heard him say that. I don't know if that's true or if that's possible because it didn't come from me. I was flying.
Tremaine
so
testify.
I know that's incorrect is what I mean to say.
Another liar on the stand?
I just know that that's incorrect.
Right. And you heard Mr. Tremaine testify that TMZ owns the copyright to the cabinet video, right?
That's news to me.
The cabinet video you filmed of your then husband, yes?
The copyright ownership of that is news to me. I learned that yesterday.
It's the cabinet video that you captured of your then husband, yes?
That is correct. I did capture that video, and yes, that was my husband.
The same cabinet video that was released the night before you were deposed in your divorce, yes?
That's correct.
Okay. You must have also heard Mr. Tremaine testify that the version of the cabinet video that TMZ received was incomplete compared to the video the jury saw in this trial. Did you hear that?
The video that you have seen is complete.
Right. But the one TMZ got the day before your deposition in the divorce was incomplete.
I don't know. I haven't seen it.
He testified that at the beginning portion of the video where you set up the camera, that wasn't included in the video that TMZ received.
I don't know what video TMZ received.
I'm talking about Mr. Tremaine's testimony, Ms. Heard. Let's just focus on Mr. Tremaine.
You're asking me to repeat his testimony?
No, I'm asking you if you recall hearing him say those words to this jury.
Yes, I heard his testimony. We all did.
And he testified that the end of the video where you can be seen smirking. I know you testified earlier that you haven't been smirking in this trial, but you sure were caught on camera smirking in that video.
I disagree with that.
Was also not included in the TMZ video.
Everyone can watch that video and you can determine whether you think it's funny to me or not.
That's because the video came from you, right, Ms. Heard?
No, it did not.
You edited out the portions.
That video did not come to me. I mean, come from me.
Ms. Heard, you edited out the portions that made you look bad before sending it to TMZ.
You're very wrong about that.
So that
if I wanted to
Mr.
leak
Depp
information, I could have done it in a more effective way, a lot sooner and a lot more.
Because
I was
exactly
living with a mountain of this evidence. If I wanted to leak it, I could have done a lot more with it.
I thought you testified earlier in this trial that you didn't know how to leak things. Remember
I don't.
That? Right. You edited that video before you gave it to TMZ so that only Mr. Depp would look bad. Yes?
That's absurd.
Right in the middle of your divorce proceedings.
Again, you're very wrong.
I'd like to show you a picture that's already admitted into evidence. It's Defendant's Exhibit 799. This is you at the courthouse on May 27, 2016, when you got your domestic violence restraining order against Mr. Depp, right?
It is.
And next to you is a woman named Jody Gottlieb, right?
Yes, yes.
Jody Gottlieb is your publicist?
And dear friend.
Now I'd like to show you what's been marked as Plaintiff's Exhibit 1316. This is a picture of you and your friend Rocky Pennington, right?
That is correct.
Your Honor, I'd like to move to admit this photograph.
Any objection to 1316?
No, Your Honor.
All right, 1316 in evidence. You can publish to the jury.
This is a picture of you on May 28th, 2016, right, Ms. Heard?
I don't know when this was taken.
This is the day after you obtained the domestic violence restraining order against Mr. Depp, right?
I have no idea when this image was taken. I did not take it.
There's no bruise on your face in this picture, is there?
Again, I don't know when this was taken, and also I'm outside. I was obviously wearing makeup. I have no idea when this was taken, so I have no idea if I can speak to what bruise you can see or not.
Let's refresh your recollection about when this picture was taken. Can we please pull up Plaintiff's Exhibit 1315, just for the witness? This is an article dated May 30th, 2016, right, Ms. Heard?
That's what it says, yes.
And this article contains the same photograph of you and Ms. Pennington we were just looking at, yes?
Yes, I see that.
And the article is entitled, Amber Heard Smiles as She Puts Arm Around Friend One Day After Getting Restraining Order Against Johnny Depp. Is that what the title says?
I know that's what the title says, yes.
Your Honor, I'm going to move to admit and publish the article with everything but the headline and date and the photo redacted.
Objection, Your Honor. That's inconsistent from the way you've treated all of these.
I'll sustain the objection. All right, next question.
Let's take a look at picture Plaintiff's Exhibit 1317. This is also a picture of you and Ms. Pennington on May 28th, 2016, isn't it?
I don't know when this photo was taken, but it looks like the same outing as the picture prior.
Your Honor, I'm going to move to admit and publish Plaintiff's Exhibit 1317.
Any objection?
No, Your
All
Honor.
right, 1317 in evidence. You can publish.
There's no bruise on your face in this picture either, right?
I disagree. If it is taken when you represent it was taken, then obviously there's a bruise on my face. It's covered by makeup, as per usual.
Let's zoom out of that picture for a moment, please. Thanks, Tom. That's Josh Drew in this picture, right?
Yes, that's correct.
And Ms. Pennington?
That is correct.
In there too?
That
Ms.
is
Pennington
correct.
submitted a sworn statement on your behalf in support of your domestic violence restraining order, didn't she?
I believe she did, yes.
Mr. Drew also submitted a statement in support of your domestic violence restraining order.
I believe they both did, yes.
Ms. Heard, I'd like to show you Defendant's Exhibit 512, which is already in evidence. You've seen this photograph before, right?
I have.
On the second day of your direct testimony, you testified that this was taken in the downstairs of the main apartment on December 15th, 2015. Do you recall that testimony?
Yes, I believe so.
So it's your testimony that Defendant's Exhibit 512 reflects damage to Penthouse 5 that occurred during the December 15th, 2015 incident, yes?
I'm not quite sure from what incident this is when I see this photo in a vacuum without context.
Let's give you that context. Can we please, thanks, if I could have day 16 trial testimony? Your Honor, may we approach?
All right.
Could you please turn first to page 4585?
Sorry, one second.
Specifically starting on line 16, where it says, let's talk about December 15th, 2015.
You said 458. I'm on 4485. Sorry, you said 4585.
4585.
Pardon.
line 16. Line 16, where it says, let's talk about December 15th, 2015. Do you see that?
Yes.
Okay. And then do you see that your testimony about December 15th, 2015 follows?
Let's see. It's just the first line or two. Yes.
Okay. Now I'd like you to turn to page 4603. Starting at line 12. 4603. Starting at line 12 and going on to page 4604, line 4.
Okay.
And do you see that you testify that Defendant's Exhibit 512, which is on the screen,
Yes.
is a picture of the downstairs of the main apartment?
That's correct.
And the main apartment is Penthouse 5 in the Eastern Columbia building, right?
No, well, depends on what. The main apartment's penthouse 3, generally, when we say main apartment.
Penthouse 5 was where you had your closet?
The downstairs was kind of like had some of my painting studio set up and a reception area. Upstairs was the closet. Mezzanine office was in between.
All right, so it's your testimony that Defendant's Exhibit 512 reflects damage to the penthouse, Penthouse 5, that occurred during the December 15th, 2015 incident, right?
I'm just not sure from which incident this is a picture of, since I'm only looking at
Even
a
though your
partial
counsel
floor.
was asking you questions about December 15th, 2015, and then admitted this picture into evidence
Again,
in relation to that incident.
Sorry, go ahead.
In relation to that incident on December 15th, 2015. This exhibit, Defendant's Exhibit, you are the defendant, number 512, was admitted into evidence in this court. You testified that this was the result of damage that occurred on December 15th, 2015. Yes or no?
I just need to orient myself because I'm just looking at a picture of a partial picture of a
Ms. Hurd,
floor,
you didn't just
so
look
I
at a
can't.
picture. You looked at your testimony.
You pointed me towards the page and then asked me a question. I haven't actually reviewed it. I don't know if this was submitted in relation to that incident.
Let's actually leave up Defendant's 512 and please pull up Defendant's Exhibit 725, which is already in evidence
Thank you.
in redacted form, Your Honor.
All right, thank you. You can publish.
Just side by side. You've seen this photograph as well, right?
I have.
On the third day of your direct testimony, you testified that this photograph reflected spilled wine in Penthouse 5 on May 21st, 2016, didn't you?
Again, I don't know because I'm looking at a partial picture of a floor. So unless you remove the metadata you've covered up, we could then tell. If you
I didn't cover it up, Your Honor.
Could we unredact
Your Honor,
them so we could get context?
That's how it's in evidence.
That's how
All
it's in
right.
evidence.
Next question.
Well, the metadata next to it is so that
Ms.
to
Hurd,
avoid this
Ms.
sort of
Hurd,
confusion.
there is no question pending, and I would appreciate it if you wouldn't be making argument to the jury.
Sorry, I
It's
thought you had
inappropriate.
asked me about it.
No, I didn't ask you about anything. Let's look at your direct testimony from the third day. May I approach?
Yes, ma'am.
Thank you. Thank you.
Let's turn to page 4750 in day 17 transcript.
Sorry, can you repeat that?
4750. Specifically line 16. Do you see where Ms. Bredehoff asked you to describe for the jury what took place on May 21st, 2016?
I see that.
Okay. And do you see that your testimony is reflected about May 21, 2015?
Yes.
That follows? Okay.
Yes.
Now let's turn to page 4804 at line 14. 4804. Starting at line 14
Yes.
through 4805, line 4.
Going to what line?
Line 4 at 4805. Do you see that you're testifying that defendant's exhibit 725, which is reflected on the right side, reflects spilled wine on the floor in penthouse 5?
That's correct.
Okay. And defendant's exhibit 512 and 725 seem to be different versions of the same picture, don't they?
That's correct.
Okay. So which is it? Which one was taken on December 15th, 2015, or May 21st, 2016?
If you remove the redacted metadata, you can find out. It's right there.
Or if you're telling the truth, you would know.
Recognize a portion of spilled wine on a floor, and I'm supposed to know off the top of my head when you've
No.
lived through 5 years of this stuff? I don't think so. That's not how that works.
Okay. Thank you, Tom. Ms. Hurd, at the beginning of your cross-examination
Your
last
Honor, may
week...
we approach?
Yes.
All right, ladies and gentlemen in the gallery, I would ask that there be no words or no phrases, no words, no sounds at all coming from you. If I hear one more sound, I will clear the gallery and we will continue this testimony without anybody in the courtroom. Understood? Good. All right, your next question.
Ms. Hurd, at the beginning of your cross-examination last week, I showed you an audio where you told Mr. Depp to tell the jury, tell the judge, tell the world that he is a victim of domestic abuse. Do you remember that?
That's correct.
And you testified you found it hard to believe that Mr. Depp would tell the world that he's a victim of domestic abuse, didn't you?
I said I find it hard to believe that he would do that knowing that he himself had beat me up for 5 years.
But he has told the world that he's your victim of domestic abuse, hasn't he?
Well, he started to say that only recently. He didn't make that claim up until very recently. So when we signed our divorce agreement and we signed a statement saying that neither party had ever said false claims for financial gain, it was relevant and important to me because I was the only one making the accusations. I was the only one making those claims. He wasn't doing that at the time, and he signed his name to it.
You didn't expect as many people to show up and testify on his behalf that did you?
Incorrect.
When you told this jury under oath that you never assaulted, actually, strike that, sorry, Your Honor. When you told this jury under oath that you punched Mr. Depp because you thought of Mr. Depp pushing Kate Moss down the stairs, you didn't expect Ms. Moss to agree to testify that never happened, did you?
Incorrect. I know how many people will come out of the woodwork to be in support of Johnny.
So you think Ms. Moss needs to come out of the woodwork to testify for Mr. Depp?
Everybody who was around in the 90s and the early aughts knew that rumor. I had heard that rumor from multiple people. Of course, that's what flashed through my head when my violent husband not only swung for me, but all of a sudden swung for my sister. Of course I thought of that. I did not expect her to show up or not expect her to show up. It didn't matter. It doesn't change what I believed at the time when we were on the stairs and I thought he was going to kill my sister by pushing her down the stairs.
You told this jury under oath that Mr. Depp was aggressive and trashed a trailer in Hicksville. You didn't expect the manager of the Hicksville property, Morgan Knight, to come forward and testify that that was untrue, did you?
Incorrect. I've already been through trials with this man. I know how many people will come out in support of him.
When you told this jury under oath that you had no idea that the paparazzi would be at the courthouse on May 27th, 2016, you didn't expect a TMZ employee to show up to testify that TMZ had been alerted that you would be at the courthouse and knew exactly which side of your face to take a picture of, did you?
I know how many people will come out and say whatever for him. That's his power. That's why I wrote the op-ed. I was speaking to that phenomenon. How many people will come out in support of him and will fall to his power? He is a very powerful man, and people love currying favor with powerful men.
Currying
and I know
favor
that
and
firsthand. I've
risking
lived
jail
it.
time for committing perjury?
Excuse me? I didn't hear your question.
You didn't hear
Excuse
my
me?
question?
Ms. Vasquez, if you do mind, please just repeat the question. I didn't hear you.
Curry favor and commit perjury in this courtroom?
I have
For a
seen people
powerful
do this.
man?
I have seen people do this time and time again. That's why I wrote the op-ed.
You didn't expect Ben King, the house manager in Australia, to show up from England. He flew from England to testify that Mr. Depp's fingertip was found exactly where he said it would be. Did you?
I have never heard Johnny testify to knowing where his finger was, or really, frankly, making a claim that he knew where it was when it was found. I've never heard Johnny claim that.
You didn't expect Keenan Wyatt.
Johnny has never
Ms.
actually
Heard,
said that.
Ms. Heard.
And
I think the
Ben
jury
King,
can.
yes.
Ms. Heard, there's no question pending. You didn't expect Keenan Wyatt, Mr. Depp's longtime sound technician, to show up and testify that Mr. Depp is not being fed lines through his earpieces, but instead music, did you?
Not that it matters much, but of course I did. I know how his employees treat him.
So you
I know how
probably-
his team treats him. Of course I expected that.
Okay, so you probably expected Isaac Baruch to come and testify for Mr. Depp, right?
I'm not sure I thought about that.
Yeah. But you didn't expect Mr. Baruch to weep for Mr. Depp after what you've put him through and so many others with your lies.
I
did you?
relate to Isaac because he and I are
There's
the
no
only
further
ones who
questions, Your
cried
Honor.
on this stand.
Nothing further.
All right. Redirect.
Thank you, Your Honor. Ms. Heard, if Mr. Baruch felt misled, who misled him?
Johnny, and I don't blame him. I don't blame him from crying. This is horrible.
Ms. Vasquez has suggested that you faked bruises on your face. Is that true?
Absolutely not. I didn't need to.
Did you ever fake an injury caused by Mr. Depp?
No.
Is any of the evidence of your injuries that has been put to the jury in this trial fake?
No, absolutely not.
And to the extent that there may be some confusion over when a picture of spilled wine was taken, why might that be?
Objection.
Because there's so
Lack
many-
of foundation.
Overruled.
Because there's so many incidents of violence. There's so many pictures. There's so much evidence. Most people don't have this kind of evidence for years, 5 years. And when I was saying that to Johnny on the phone in that recording, I was saying for years this has been going on. And I have pictures, we have texts, we have everything. Normally you don't get this amount of evidence. That's what I was pointing out to Johnny. It would be crazy to try to challenge this in this way. It's crazy. It's easy to not know the context of a picture of spilled wine because there are so many more important details, pictures, and also so much I didn't photograph, so much I didn't have the presence of
Objection,
mind to
non-responsive.
document.
All right, I'll sustain the objection. Next question.
Did Mr. Depp abuse you physically?
Yes.
Verbally?
Yes.
Emotionally?
Yes.
Psychologically?
Yes.
How did the threats that Mr. Depp made against you individually years ago resemble what you have endured as a result of the Depp-Waldman statements?
Beyond the scope of cross, Your Honor.
Overruled.
Johnny promised me he would ruin me, that he'd ruin my career, he'd take my life from me. Death was the only way out, and if I got out, this is what he'd do to me. He'd make me think of him every single day. He promised me global humiliation. You saw those texts. What he couldn't do, the work of one individual, meaning Johnny, when he was inviting a disgruntled employee over for a spot of purple to fix my flabby ass up. That revenge that he sought back then was just what he could do as an individual, calling the studio to get me fired, trying to block
Objection, Your Honor. Lack of foundation, speculation, hearsay,
all in
non-responsive.
I'll sustain it as to non-responsive.
Ms. Hurd, how did those things that you just testified to that Mr. Depp did, how did those resemble what happened to you after the Depp-Waldman counterclaim statements were made?
Well, those are
Objection, Your Honor. Lack of foundation.
She's
Overruled.
Thank you. Thank you, Your Honor.
Those are just an echo of what I'm living through today. It's like what I'm living in right now. What you see in this courtroom is an echo. This courtroom and the other courtroom he dragged me into to do the same thing again. That's just an echo of the violence and the abuse that I suffered within our relationship. The campaigns to have me fired, the blocking me to try to ruin my career, the threats he's made to humiliate me globally are being lived out in real time in front of you, ladies and gentlemen, for the past 6 weeks and for the whole world since our camera's here.
No further questions. Thank you so much, Amber.
All right, Ms. Hurd, you can have a seat next to your attorneys. If I could have the attorneys approach. Witness.
Your Honor, the counterclaimant Amber Heard rests.
All right, thank you, ma'am. All right, ladies and gentlemen, you have heard all the evidence you're going to hear in this matter. What I propose doing is to go ahead and give you the rest of the afternoon off so you can have a good restful afternoon and evening, and we will do closing arguments tomorrow morning at 9 a.m., and then the case will be submitted to you for deliberations. Just to give you a little logistics of how that will go, tomorrow I won't give you a time limit as far as how long you can deliberate in the afternoon into the evening. I will tell you, within reason, I will tell you I do not serve dinner, so keep that in mind, okay? You will not be deliberating on Saturday or Sunday or Monday, because Monday is a holiday. I would like you to have you back here Tuesday morning, at least by 9 o'clock. If you want to come earlier, that's up to you. You can decide as a group if you want to come earlier than 9 o'clock, but you have to be here at least by 9 o'clock to resume your deliberations again. And again on Tuesday night, and if you have to go to Wednesday or Thursday, that the time that when you take your breaks is up to you, as long as you take them together, as far as not having any deliberations unless all of the jurors are in the room at the same time. When you take your lunch is up to you. And then again in the evening, within reason, I'll let you go as long as you'd like to go, okay? So have a good evening, and we'll see you tomorrow morning, okay? Do not discuss the case with anybody. Don't do any outside research. All right. We'll go ahead and take a modified lunch recess just till 12:50. We'll come back at 12:50. We just have a few jury instructions left we have to do. Make sure we get the verdict form taken care of. I want you to review the laptop that we have mocked up and make sure everybody agrees what's on it. And also, I want you to look through all your exhibits and make sure we're all on the same page. Before you leave, I'll make sure you have copies of the jury instructions in the order that I'm going to read them, and you should be able to prepare for your closing arguments for tomorrow, okay? All right, we'll see you at 12:50 then.
All right.
Now I will stop at nothing. Let's see if Mollusk has a pair. Come see me face to face. I'll show him things he's never seen before, like the other side of his d when I slice it off. Did I read that right?
You did.
And that certainly did not look good for Johnny Depp there. So let's bring back our guest to discuss this. Catherine, how does this text make Johnny Depp look in the grand scheme of this case?
When he was being questioned by Mr. Rottenborg regarding that, it does look at first glance to be very detrimental for her because of the language and the obscenity in it. But then he was redirected by his counsel, and he explained what that was, which made perfect sense in that he said that he wrote that text because he was so angry. And anyone in his position could probably relate to what he's saying, that sometimes I presume all of us have written a text in a very angry demeanor, and it comes off like that. So I think it's understandable after he explained what that is.
Matt, could this text fuel Johnny Depp's motive to be involved in the defamatory statements Amber Heard is suing for in her counterclaim?
Well, I think it can. It can relate to that. But what I think this text does is that it exposes sort of the real Johnny Depp. I mean, we've observed Johnny Depp on the witness stand in this case talking, crack jokes. And I think, that's kind of what the jurors see of him on a daily basis. But in actuality, this is a glimpse into what Johnny Depp is like when he's sitting in his living room with a phone in his hand and jotting off, some text. And I think what it also does is today's testimony by Amber Heard, the jurors can look back at that text and say, well, yeah, we see a pattern here of trying to, attack Amber Heard at every level, even after their relationship has long ended. So I think when you juxtapose that text with what we heard from Amber Heard today, it doesn't have a good look for Johnny Depp.
Okay, so now let's listen to Depp's team trying to clear this text message up on redirect.
Mr. Rottenborn referenced that you were on the stand for multiple days.
4.5, I believe, yes.
Yeah. What was the nature of that examination? Or, excuse me, who was conducting that examination of you?
QC Sasha Was.
And whose attorney was that?
The Sons.
Can we please pull up DX 857A?
All right, it's already in evidence, so we can publish it.
Mr. Depp, do you recall seeing this text message when Mr. Rottenborn was questioning you?
Oh, yes, I do.
Can you explain what you're conveying to Mr. Carino in this text message?
I'm in total shock that this is happening to me, that my entire life on the planet has been brought to the head of a pin with all this completely, utterly false information. So I am, when you're accused of horrific acts and things that you have not done, when it's actually some very ugly things that are going out there into the world about you on a non-stop basis by Ms. Heard and her team, you have a tendency as humans to get very, very irate and angry, not to the point where you go out and hurt someone, not to the point even where you assault a cabinet. But you do get irate. You do wonder why this person is doing this to me. So yeah, many things go through your head. And then you've got your family, you've got your kids, you've got your parents. My mom, thankfully, didn't get to read any of this, because that would have killed her. But my father, my family, everyone that I've met, the people that have supported me, suddenly I'm scum. Why? Never had to happen. One little lie. So yes, very angry.
All right, so you just heard what Johnny Depp had to say about that text. And when you see something in the courtroom like that and you read it, it really is hard to unsee it, though. So, Catherine, with that being said, do you think the jury will disregard the text on the basis that Depp was just expressing himself?
As I mentioned earlier, I think they would likely do that. And let me back up and say that I agree with my colleague Matthew that something like this is indicative of how probably Johnny Depp presented himself. So we get a view of that. But at the same time, when Johnny Depp explained it in the way he did and the manner he did during that redirect, it sounded very authentic and very clear as to why he sent that text. I think all of us have had an instance in our life where we are very angry and we sent an angry text explaining our anger. I think that would come across as common sense, and the jury will just have to weigh whether or not what he's doing right now in the defamation case is indeed the global humiliation he's trying to threaten, according to Amber Heard.
And we've talked about this before. You know, a lot of legal analysts like yourselves have said that, you know, the first time Johnny Depp was on the stand, he seemed a little more genuine, a little more authentic, and he did a little bit better than he did the other day. Now, Matt, do you think Johnny Depp's team should have refrained from putting him on the stand in their rebuttal case?
Well, I mean, that's a tough decision. I mean, he did well when he testified in the past. He seemed to, win over the jurors with his humor and the other things that he talked about, in the manner in which he presented himself. I don't think he did as well the second time around. And sometimes you don't want to take two bites of the apple. Be happy with where you are and what you got, and don't try to replicate it. But here again, I think the fundamental issue with regard to this text is that Johnny Depp was angry. Okay, he was angry. He was angry enough to send this profanity-laced text to someone because of the circumstances he was in. Now, should we believe that Johnny Depp never gets angry any other time? That Johnny Depp never got angry when he was physically in front of Amber Heard, and that instead of being able to text out a message, he could physically act out against him? I think that's the fundamental issue in this case. You know, Johnny Depp, we know, used a lot of drugs, a lot of alcohol, and we know he can get pretty darn angry. Could that result in the threat of abuse or physical abuse or sexual abuse of Amber Heard? I think the jurors have a lot to think about when they put together what Amber Heard has said and what in the way that Johnny Depp has acted out in other circumstances.
Catherine, what do you think? Do you think that Johnny Depp's team should have refrained from having him on the stand again?
As Matthew mentioned, that's a tough call. I think it was good for them to bring in Johnny Depp back because he needed to rebut what Amber Heard testified to and a lot of the other witnesses. One thing that stood out for me when in that clip that we just showed, he said that, yes, I am angry. And it made me think, because like you mentioned, and like most people watching his rebuttal testimony, he sounded to be less, he sounded to be more impatient. And then when he used the word angry, it clicked to me. He sounded angry at this time that he's in rebuttal. And if we put ourselves in his shoes, he's been listening to all of this for now, 6 weeks, and hearing more and more of whatever testimony from Amber Heard's side, and also from his side, from expert, from lay witnesses. That could make someone really angry. And so when he is there now for rebuttal, I think that anger showed, and we can see the shift in his mood, and said, I am really angry. Now I'm really, really angry after hearing all of this. So I think that's the fundamental difference of his testimony before, during direct, and now in rebuttal.
All right, thank you for your perspective. You both, great analysis as always. We're going to have to take a quick break now here on Law and Crime, but don't go anywhere, because on the other side, we'll be taking your questions as we have a live Q&A session with Law and Crime's very own Jesse Weber. So stay tuned. More from Fairfax, Virginia in a bit.
And welcome to a very special For the Record, everybody. I'm Jesse Weber. Thanks for joining us. We are live right now in Fairfax County, Virginia, outside of the Fairfax County Courthouse, where earlier today both sides officially rested in the Johnny Depp Amber Heard defamation trial. We're waiting for a lunch break to finish up. We're going to hear the attorneys speak with the judge about some administrative matters, possibly some motions. The jury has been excused. They'll come back tomorrow for closing arguments. But right now, in this lunch break, this is the time when we take your questions. So if you're on YouTube, Twitch, Twitter, Facebook, you email us, any which way you can get our questions to us in this next half hour or so. We are going to answer your questions in real time. I'm back here with Catherine Lizardo, Matthew Mangino, and Jeanette Levy. We're going to take your questions right now. And Jeanette, I start with you. Something that you and I had talked about earlier. This is a question from Facebook. Felicia Horvath says, why do you think Johnny was asked questions about Amber's team about incoming text messages? Was that a trip him up? Was that a trip to trip him up, or was it a mistake on their part? The messages he denied ever saying, and I understand you also received a message about this on Twitter.
I did, Jesse, and I received this message actually late last night, and I didn't really have a chance to look at it closely. It was one of those things I just kind of glanced at it and thought I'll get to it in the morning, but I want to show you what one of our viewers sent to us, and this is our footage. They took it directly from our YouTube channel. So remember that whole line of questioning yesterday by Ben Rottenborn about these sexual texts talking about, Molly's, you know what, is rightfully mine. Should I not just bust in and remove its hinges? And I want to change her understanding of what it's like to be thrashed. And it was like, I need, I want, I take, all this stuff. Well, I want to show this to you. It's talking really derisively about women. Well, these texts were extracted from Johnny Depp's phone, right? This is an incoming text. Johnny Depp said that he didn't write it. He said he didn't write this text. He doesn't have enough hubris in him to write something like this and to think that a woman, any woman he wants, is there for his taking. So it says direction incoming. Incoming. So these are incoming text messages. The one Johnny Depp said he wrote yesterday, the one where he said that he sent to Christian Carino and said that Amber Heard is begging for global humiliation, total global humiliation, highlighted, outgoing. He admitted to writing that text message. So we don't know if that was a mistake on Ben Rottenborn's part or a mistake or if it was intentional. We just don't know. I would love to ask Ben Rottenborn about that. But this clearly is an outgoing text that Johnny Depp said, yes, I wrote that. The ones about the really graphic sexual stuff, incoming, it's stamped. So it appears possibly that Johnny Depp did not write that.
It's a bit curious. I mean, people, our loyal trial watchers were actually catching that, and a few of them caught it as well. Catherine Lizardo, question that was emailed to me from Evanescence Fan. Do you actually believe that all of the jury members respected the honor system during the trial vacation? There was a week off, but also think about this. They're off now for the rest of the day. They're going to come back tomorrow, and even during the course of this whole case, do you think they're really not reading anything about this case? Do you think they're not talking to anybody about this case? This is the biggest trial that we've ever seen. I mean, what is that a realistic possibility?
I have faith in those jurors that they are following strictly what the judge mentioned. The reason is because if they got found out that they didn't, then they will be booted out as a juror here. And there are alternates to this, to the panel of jurors that we have. So I think every single juror right now are heavily invested, having listened to this for the past 6 weeks. And like you said, it's the biggest case so far that everyone is watching. So they would not want to not participate in the deliberations. So it behooves them to really follow that strictly, although it will be very difficult, especially during Memorial Day weekend, if they happen to have any parties or gathering with their family for the long weekend. So everyone just really needs to tell their family and friends to do not talk about this trial with me right now.
Yeah, I hope the jury is never watching any of Law and Crime's footage. I hope they are not. I hope they're not seeing any of this. I hope they're not on the Q&A session right now and trying to get questions in. But Matthew, we have a question right now from one of our followers on Twitch, 3FM7DB3. If that is your username, I have no idea what your password is, but it's probably very well protected. The question is, Matthew, How does Amber Heard calling all of the other witnesses liars reflect on her own testimony on cross-examination? And does taking the stand again have any effect on her case, and how so?
I think it has an effect on her case. We talk in the law about primacy and recency. So she is the last voice that the jurors are going to hear from the witness stand. And I think that her testimony today was powerful. She stood her ground. She made it clear that this abuse, not only abuse 5 years ago, but ongoing abuse in terms of wanting to humiliate her worldwide and those types of things. She stayed on message. She was forceful. She certainly wasn't passive. I think she did herself a service by coming back and testifying today.
Catherine, we have a question from Facebook, Reem Wael. Can TMZ sue their former reporter? I believe they're talking about Morgan Tremaine. Can TMZ sue their former reporter who testified in court yesterday, or did he not divulge any information that be considered private?
Whether or not TMZ can sue him, TMZ can sue anytime, anyone can sue, but I do not think that they will do that here. One is because TMZ has just been put in this position where everyone was watching the motion that the judge denied for other legal reasons. And second, I do not think that that reporter actually revealed his source. And the way they examined him was very strategic and very precise. They just wanted to point out to the jury that someone leaked the information about the TRO and the video of the cabinet to them, and the person who has the copyright actually gave them that ownership. And who owns that copyright other than the person who shot that video, and that would be Amber Heard. So I think they did that very well without revealing his source, because this journalist too, former employee of TMZ, would want to keep his integrity as well and not be sued or not be banned by other media as well for having a reputation of revealing sources. So I think they did that well, and he did that well as well.
Yeah, he had said on the stand that, he has nothing to gain from this. TMZ is quite litigious, so it's something to think about. So we have a question, Anjanette, from Soph on YouTube. So what happens with the rest of the hours that Johnny's team still has left? Does it not matter anymore? Because remember, there were time limits on the presentation of their case.
It doesn't matter. It's over. So they budgeted their time very wisely. Who knows what they would have needed on rebuttal? They had to do that. They had to bank some minutes and some hours. So I think they did a good job of doing that. I don't know what the final count was, how much time Amber Heard's team used, but they used up quite a bit of time, as we've discussed many times.
Well, Matthew, I have a question from one of our YouTubers, Pranav Gosalia. How much does the likability and believability of the witnesses affect the jury? What are your opinions about this regarding Johnny Depp's witnesses versus Amber Heard's witnesses?
Well, they have everything to do with the success of a case. The likability, although, we should be listening, or the juror should be listening, to this technical evidence and how it applies in this case, and not really, thinking about, well, this guy seems like a pretty decent guy who's talking right now, or this woman is really friendly and I like her. But that's the reality of it. I mean, that's the reality of jury trials. Jurors are looking at this from their own personal lenses as well, and whether they like somebody, it might tend to let them believe that person more than someone that maybe they didn't care for. So, as trial attorneys, we deal with these issues all the time. We might have a great case, but we have poor witnesses, and that has everything to do with success. And I think it will have an impact on this case as well. The other issue is the two parties in this case. Who was likable, who wasn't likable, who did you like more, who did you dislike? I mean, that's going to have a significant impact on the outcome of this case, and it always does.
Well, speaking of the outcome of the case, I had a question emailed to me by Sean Hilgenberg, and the question is, I'll throw this to you, Catherine. What happens if Johnny Depp wins? Will there be an appeal? Will it become a long, drawn-out verdict? Can Amber Heard afford the payments?
If Johnny Depp wins the legal case of defamation against Amber Heard, yes, Amber Heard can appeal. Whether or not she will do that, we'll wait and see. And whether or not she can afford that, that's a question too, because she has testified that Johnny Depp's current lawsuit has made it difficult for her financially, specifically also in terms of complying with her pledge to ACLU. And the fees and costs relating to an appeal is also very expensive. So tack that on to the fees and costs she's already incurring with this trial. That is going to be a huge amount for her to take on. So on appeal, that is definitely something to think about when you're thinking of appealing whatever the jury decides in this case.
So, and Jeanette, we have a question over to you. This is from, actually, I should tell you, the question for you was from OC Cali Girl 49 on Twitter, and it's about you being in the courtroom, but my understanding is that we couldn't get in the courtroom today because people were actually cutting the lines. The question was, how was the jury reacting during the cross-examination between Amber and Camille? I'm dying to know this, but I won't ask you that. I'll ask you this question from Starberry on YouTube. Can something be concluded from the way Heard behaved depending on the attorney's questioning? She was so vulnerable and emotional with Rottenborn, but extremely defensive with Vasquez. What's your thoughts there, Anjanette?
Well, she was being pinned down on some pretty, I think, key points by Camille Vasquez. The TMZ stuff. The TMZ testimony is so damning for Amber Heard. Morgan Tremaine said that he was dealing with the copyright holder because it was such a quick process. So I think that was very damning. The stuff about, you know, the TMZ being there for the photographing of the bruise, and then the next day this photograph of her with Rocky Pennington without the bruise, and she said, well, I must have been wearing makeup. I think these are key points, and they're key points for the Depp team. So I think that Amber Heard, we've seen and we've heard in the audio recordings, is not somebody who backs down and doesn't back down easily. And so I think that's just going to be something the jury is going to have to look at. And the fact that she never concedes that she's made mistakes or done anything wrong. That's something I've noticed throughout her testimony. We all do things that are wrong. We all screw up. We all mess up. So none of us is perfect. So I thought that was interesting. I just do want to point out, though, as I was walking off the 5th floor of the courthouse, I walked past a gentleman who had been in the courtroom, and he said that Whitney Enriquez walked past him, and he looked at her, and she looked none too pleased. I won't use the word that he used. I tweeted it out, but he said she looked pretty angry.
All right. Well, that's an interesting, observation of what's happening with other people there. It's interesting. We're taking more of your questions. We are waiting to jump back live. We're going to see what happens next with the attorneys and the judge. Matthew, we have a first-time chat question from one of our Twitch followers, Harshad Laki. Could either party contest the verdict in a higher court, or is this decision on the case final?
Well, no, there's always available in any trial appellate review. So either party could appeal this case to a higher level. Again, don't forget, we're looking at sort of two cases in one. We have the original defamation case and we have the countersuit. So there's a lot of opportunity here, for review. Depending on what the verdict is on the original claim, depending what the verdict is on the counterclaim. So yeah, this process will probably not end here. The other issue is if there's a verdict and there's a significant award to one party or the other, that's certainly going to trigger the losing party to file an appeal. It's not as though once this case is over and the jury says you owe $10 million that you got to pull your checkbook out and write a check for $10 million. That's not the way it works. So yes, there is going to be a review of the verdicts in this case.
Will our cameras be set up at a higher, outside of a higher court? I don't know. We'll wait and see. In the meantime, we're going to take a quick break. We are waiting to jump back live into that courtroom that you see right behind me. So we'll take a quick break. We'll take more of your questions on the other side before we have to jump live. Live right now outside of the Fairfax County Courthouse, we're covering the Q&A session where we are taking your questions on YouTube, Facebook, Twitter, Twitch, however you can get your questions to us on the Johnny Depp Amber Heard defamation trial. Both sides have officially rested. We're waiting to jump live with the attorneys having a meeting with the judge. We'll hear if there's going to be any motions argued. Right now we have a question to you, Catherine Lizardo, from Roni Anaya on YouTube. Amber previously testified that she did not write the op-ed about Johnny. During cross today, she just admitted she did write it about him, and he was why she wrote it. How do you think that's going to affect things?
It will significantly affect things because the core of Johnny Depp's defamation trial and claim is about the op-ed. And in the defamation case, in a defamation claim, one of the elements you have to prove is whether or not Amber Heard wrote the op-ed. Now, we've seen a lot and heard a lot of testimony about that. We know from the ACLU's general counsel, they testified that it was written by ACLU, but at the same time, it was also approved by Amber Heard, and it was a collaborative effort between the two of them. I think there would not be any dispute that Amber Heard wrote the op-ed, so it's
to do anything about it.
Right.
So I think it might just be that it's in evidence. However, it's not going to go back to the jury because it's corrupted. Okay, does everybody agree to that?
Yes, Your Honor. Thank you. It's
Okay.
just an Eastern Columbia building video, so that's fine.
That's just, just it's corrupt. Okay, do you have more exhibits to give? Good. Let's get Jamie here. All right. All right, so these, you want to get your list, Jamie, and make sure? Go ahead. All right, it's defendants 393, 821, 857, 857A, 883, 1859, 1905. Make sure that's nothing. It's the second page of that. 1050.
Yes.
It seems to be a longer one. Hold on. And I think that is it, correct? All right. Are you missing any other exhibits?
Your Honor, if I may approach.
Yes,
we
you have some?
from
Okay.
today. Yes.
Let's go ahead and get those. All right, so these were the two through. Oh, these. All right, so we have. Okay, I think this one's theirs. All right, so I have plaintiff's exhibit 1316 and 1317. Yeah.
I still need 1301.
1301. Does anybody have 1301? Plaintiff's 1301.
It was an Instagram post.
An Instagram post.
We'll get it, Your Honor.
And then that 711A and 711B from today.
711A and 711B, the one without the metadata, one with the metadata showing. It was the same pictures, but it showed the metadata.
I believe that was 712A and 712 and 713A.
Yes,
I don't have those.
we just don't have them. 712 and 713A.
Understood. Okay.
Can I get them now?
Yes.
I'm trying to get all the exhibits together right now so we have them all together so we can review them.
And then the other one is 120D is not in evidence, but it was on their list as in evidence.
120D, as in David?
Yes.
So 120D was listed as, you had it as in evidence, but we do not have it in evidence. All right. Is that all the pieces of evidence?
Yes.
Excellent. That's good. Good. Okay, so we are very close to getting all of that. I don't want to leave here until we have every piece of evidence with Jamie and everybody has reviewed it, so we don't have to review that tomorrow and waste time with that. Okay? All right, so now I think we can do jury instructions, correct? All right. Let me just go over the ones that we had a few issues with. At the first one I'm going to go over is the self-defense. There's two, that would be number 28 and 29, correct? And I took those under advisement. Do you still have an objection to the self-defense? All right. So what evidence do we have in trial that would allow to have these two jury instructions?
Sure, Your Honor. So I think there's evidence in the record showing that Mr. Waldman was Mr. Depp's agent, that he was retained in connection with the UK litigation and with this litigation. There's evidence that he engaged with third parties in that capacity, that he met with the Daily Mail with Mr. Depp, and that he believed Mr. Depp's version of events. And so I think all of that, is relevant evidence to a self-defense, that Mr. Waldman made those statements in self-defense on behalf of Mr. Depp.
All right, so you're saying if agency is found.
If agency is found.
We believe they're inappropriate, Your Honor. First of all, we have not been able to locate case law, but
We found one from 1887.
That might have been, and I know I had seen one
We said it was a reversible error if you didn't give the self-defense one. So,
well, I know we had taken a look at one a while back. I think, but I don't have a case cite for you. I think it's a question of law as to whether it applies. And so at a minimum, I think we should figure that out, I guess. But the reason we don't think it should apply is these were statements that were made by Mr. Waldman in 2020. I guess it was before Ms. Heard's counterclaim. So if he's saying that
it goes to the op-ed, I think.
Understood. So if he's saying that this lawsuit was a statement in response to the op-ed, the statements that were made a year and a half later by Mr. Waldman, and it doesn't, I mean, again, Your Honor, the key words are fairly and reasonably. So obviously both sides are going to argue defamatory implication and what did the op-ed really mean, and did it say these things. But saying, even under their theory, 2 years ago I became a public figure representing domestic abuse, to say that then it's fair for Mr. Waldman a year and a half later to make public statements that Amber and her friends roughed up the place and spilled a little wine, all the things that he said in those statements, that's not fairly and reasonably. Ms. Heard responded fairly and reasonably to Mr. Depp's case through her counterclaim. The parties can speak to each other in the courtroom here, but saying that if someone makes a statement in an op-ed that then you can go and do whatever you want for 2 years, say whatever you want. And obviously there's only 3 statements that comprise the counterclaim, but as the evidence has shown, it was part of a pattern by Mr. Waldman. It's the opposite of proportionate. It's the opposite of fair and reasonable response.
Okay.
Mr. Depp's opportunity for a fair and reasonable response, well, we don't believe it was either, but he had the opportunity to file a lawsuit in this court.
Right.
To have Mr. Waldman be his attack dog and to say anything Mr. Waldman then says as his attack dog is somehow fair and reasonable and entitled to the privilege is inappropriate. And I do think that before Your Honor gives it, we need to confirm whether it's a question of law.
Okay.
Your Honor, Mr. Roddenborn noted that this lawsuit was a response to the op-ed, but I think there could be multiple statements in response to the op-ed, so I think that's not dispositive of anything. And the statements were clearly a direct response to Ms. Heard's allegations on their face, and whether that response was fair and reasonable is a jury question.
I don't. What do you say is the matter of law? The privilege of self-defense is a matter of law?
I think it could be whether it applies.
Okay. I don't think it's a matter of law. I think it's whether or not if there is any evidence that a jury could find it being protected speech, not the weight of the evidence, but if there is any evidence. And I don't think it's my role to weigh that evidence as far as how long it was made afterwards.
I think it is, Your Honor. I mean, it can't be the case that any time there's an alleged this is why this doesn't come up often, because this just isn't given. If it were appropriate here, every time there's a defamation case, this would be an instruction. Even the person who's the defendant in the case who said, "Well, all I said I was responding to something that was said before."
So all your evidence that you say goes to the jury are just the statements. That's why this should be given. That he made the statements. That's the only evidence.
Well, I think
You gave me evidence of agency, but that's just agency. Do you have any evidence that of self-defense that he actually said these statements because of what she said?
Well, I think there's circumstantial evidence, at least, that so it's agency. He's an attorney who was retained in connection with this litigation and the UK litigation.
That doesn't automatically give you self-defense, though, a privilege of self-defense.
And that's
you have to make them. I have to have some evidence that the statements were made in response to the direct accusations of Ms. Heard. Some evidence.
On their face, they appear to be a direct response.
Not the statements themselves, but is there any other evidence? But the statements fairly arose in response to Ms. Heard's accusation. Did anybody testify that he made these statements in response to her op-ed?
No.
Not that I'm aware of, Your Honor.
All right.
Your Honor, just one small point there. There's no requirement that it be in response to the op-ed in particular. The question for self-defense to apply is simply whether it's made in response to an allegation against Mr. Depp. And Mr. Waldman's evidence is clear, I think, that he was responding to allegations against Mr. Depp, and he believed those allegations to be false. There was extensive evidence in the record on that, in fact, I think.
that he was responding to. So if it's not the op-ed, then we're really in murky ground. If he says, well, I was responding to what she said in 2016, that's...
Well, what Mr. Muniz is saying is that you take it as a separate case. You take it as a separate case, their claim and then your counterclaim. So your counterclaim is a separate standalone case, right?
Okay.
So the standalone case doesn't, your claim doesn't deal with the op-ed. So they're saying in defense of your case, that's why this comes in.
But he couldn't have made the statements in defense of our case because these are the basis for our case. So what was he responding to if it wasn't the op-ed? And if it's not the op-ed, then we're really in murky ground because there's no, plus, Your Honor, a couple points. To your point, there's been no testimony that he made these in self-defense to anything. Two, the defense doesn't apply, and this is, this is under the Haycox case, 1958. It doesn't apply if we prove malice. So it has to be made in good faith and without malice. So it's coextensive. I could bring the case up if you want, Your Honor. So if the malice inquiry incorporates this. This is the, let's see, 200 Virginia 212, Haycox versus Wilcox Dunn. And it looks like on page 231, they're discussing a Massachusetts case, and that says, statements made in an honest endeavor to vindicate one's character or to protect one's interests are usually regarded as qualifiedly privileged, even though they are false, if they are made in good faith and without malice. So the malice inquiry takes care of this. In addition, I don't think I need to remind the court, but for the record, Mr. Waldman was not allowed to answer any questions about this. So to say, well, he could have been making it in defense of something, they could have let him answer questions and get that evidence on the record. They can't say, well, he could have been making it in defense of something now.
And when I say, just looking at your case, you're claiming these alleged defamation, the three we have allegations. Well, they're saying in response that they made them because of something she said that maybe is not the op-ed.
But then there's no evidence of what that is. She was sued. She said 2016 when she made her Then 2018 she has the op-ed that have a couple words that they're trying to turn into what we've just seen for the last 6 weeks, and then she responded to the lawsuit. Okay. So it can't be the case that by trying to defend yourself in a lawsuit that was brought against you, if it's not the op-ed, then it's got to be her statements in the lawsuit. That somehow trying to defend yourself through judicially immune statements in a lawsuit entitles someone else to go out and say whatever they want and then try to veil themselves in the privilege.
The counsel for Ms. Heard made a point of making clear that there was extensive allegations about Mr. Depp circulating. They repeatedly brought up the UK action, which was in fact the context in which I believe these statements were made based on the date. It was very close in time to the UK action. They brought up the Dan Wooten article. These allegations date back to 2016. These allegations are out there, and there's evidence, from which the jury could find that Mr. Waldman was acting in defense of Mr. Depp.
Well, no, acting in defense against Ms. Heard's accusations. So what are Ms. Heard's accusations that would be defense, that are in evidence?
Your Honor, there has been extensive evidence of the accusations against Mr. Depp going back to 2016. For example, the Dan Wooten article that they raised in evidence prior to the op-ed, which included the word wife beater, and was essentially,
But it has to be.
That's not Ms. Heard's statements.
Ms. Heard's statements. Right.
I don't believe that's correct, Your Honor. It doesn't have to be
against Ms. Heard's accusations. It is correct.
That would be crazy, Your Honor, if they get a jury instruction because he was responding.
I understand that.
Again, the number of allegations made by Ms. Heard, it's been very well documented in this case. You have the op-ed, and it doesn't have to be it doesn't have to be any one particular allegation, but you have the op-ed, you have the People magazine article, you have the republication of her statements through the wife beater and the Dan Wooten article, you have the fact that she was giving testimony in the UK action about these issues.
Well, then would you agree that actual malice, you don't get the self-defense if there's actual malice in his statements? If the jury finds actual malice, then you don't get.
If the jury finds actual malice,
then it's not protected
that may
speech.
obviate the privilege, but that doesn't mean that the privilege is not applicable or a valid.
But the only way they can find in this case is if there is actual malice. This goes back to their defense, slap defense as well. The only way they find defamatory statements in this case is if there's actual malice. And it's unique to this case, I understand that. But so if they find actual malice in defamatory statements, you don't have protected speech privilege.
And if there's no actual malice, they win.
Yes,
So-
correct. The same with this. That's why we're
right.
not giving a jury instruction on the slap defense,
Right.
because there's no basis for it.
What do you think?
I mean, if the instruction is not being given on the understanding that it's essentially moot,
Which I agree. I think what's what happened with the slap defense as well. We found out after we went down that legal road, we found out that was moot as well. Okay. So do you want me to deny it or withdraw it? I'll do either one.
if you don't mind denying, Your Honor.
Okay, that's fine. I'll deny. That's instruction 28 and 29. Okay, put that in the deny stack. All right, next one I have is the republication one. Okay. So I see both of them dueling paragraphs for the republication. Yes, sir. And I understand last time we spoke that you must determine whether any content that was added constitutes a republication. And you just would rather have just the 3 sentences as yours for republication. Is that correct?
Correct, Your Honor.
That didn't.
No,
Well,
I
you
think
must
it's
find
the
that she read, or you want to add that into it? I'm not sure. I'm just not sure how I'm reading it.
I think, and I don't mean to put words in their mouth, I think we want the whole thing at the top.
Right.
And they just want the one sentence at the bottom.
Okay, that's correct.
And, Your Honor, we talk about not going backwards. We went over
No, I
this on
understand.
Friday. Your Honor said that on page 92 of the transcript, I don't have a problem with the republished jury instruction. I just think it has to be accurate with adding the language. And
Right.
that language was on page 89. You said, but you also have to say, but adding content to it may establish republication. So that's what we did in the sentence that starts with merely linking.
Right.
It did say merely linking to an article does not amount to republication, period. And then we added directly from the transcript, but adding content to it may establish republication. So now they're going backwards. They just want you to strike the whole thing except the first sentence. And that's different from Your Honor's ruling on Friday, and also doesn't fully capture.
No, it
the
doesn't
republication
capture the whole
doctrine.
legal argument.
And if I may just make our argument for the record here, Your Honor.
Well, you did on Friday, but if you want to do it again, that's fine.
Okay, just very quickly. So I think the issue with republication is whether it reaches a new audience, which is what we
and that's there.
What we propose, right, it's included in their instruction. I believe it should be limited to that.
Okay.
Lakova is a case that they've repeatedly cited in support of this republication issue, and that's a case where there was a defamatory New York Times article that was hyperlinked in a more recent New York Times article, and the court said that that's not directed at a new audience. It's the same party tweeting to the same audience, so there's no republication. And that's not the case here, where Ms. Heard has retweeted a Washington Post article. So that, Ms. Heard's audience on Twitter is different than the Washington Post. And so
But if she just retweeted a hyperlink, that's different. But in this context, and that's why I took the motion to strike under advisement, once I got it, there was more content to it. And that's why I'm putting it in the jury instruction, because it is accurate that a hyperlink alone is not enough to reach a new audience. But I'm willing to, what I think would also add to it, though, is after you must determine whether any content that was added constitutes republication. And let's see, I would say then you must determine whether any added content republished the op-ed to a new audience. I could say it that way. Or I could say, but adding content to a linked article may constitute republication. You must determine whether any added content was intended to reach a new audience. If you find it was intended to reach a new audience, it constitutes a republication. I could say it in that term. Add that to the end of that paragraph.
I think that's fine if that's the court's inclination.
Do you have any objection to that?
I'm thinking. Sorry, I'm
Okay.
slow on
Repeat it
the
one more time.
Yeah, that,
Sure, okay. Let's see. All right, let me see if I can incorporate it into it. Okay, so merely linking to an article does not amount to republication, but adding content to a linked article may constitute republication. You must determine whether any added content was intended to reach a new audience. If you find it was intended to reach a new audience, it constitutes a republication.
I think we would prefer just to say just that first sentence, merely linking to an article does not amount to republication, but adding content to a linked article may establish republication, period.
Well, that's what you already had. This is
No, because we had you must determine whether any added content that was added constitutes a republication. I think it'd be better to just delete the last two sentences than to add the sentence at the end.
Your Honor, I just want to note, I don't think that adding content is a requirement for republication. I mean, we've found a number of cases that when somebody repeats a defamatory statement, that they're as liable as the original defamer.
We're not going back. We're not going backwards. So either it's his language or my language. What do you want?
I prefer the court's language.
All right, then I'm going to put my court's language. Okay.
Do you want us to do the revisions? Because if you do it, we may have to just get one more time from you.
Okay.
We're happy to, or
Sammy, can you do it? Okay. You gave him to him in Word format?
we did.
All right. Can you do that? Here.
The only other thing I would note is I think the word retransmitted in the second line is misspelled. So
In the second line? Okay. All right, we'll take care of that. But adding content, just do it. Adding content, yeah. It's like this one right here.
Okay.
And then just get rid of all of this and add this instead. We'll take one, okay? All right, and we'll clean it up and just take out the box. Okay, we'll get that done.
Okay.
All right, takes care of that one. Next one, it's, I think, instruction FF. Defamatory meaning, consider the publication as a whole. And we have dueling answers here. And the defendant just has op-ed in it. The plaintiff just has it as plain, which, I mean, it does say that it means you may not seize any word, phrase, or image. So it would appear that so it could apply to both of them in that context.
The problem, Your Honor, is that we believe that because the counterclaim statements that the jury will be presented with are redacted, so the statements are in isolation, that there's a risk that as they're phrasing it, the jury may read the phrase, you must read the statements in context as a whole, to say, well, we can't do that, so therefore there's no liability. We think because it's impossible to read those statements in the context of the whole piece. And so that's number one. Number two, the op-ed was all Amber's statements. So the whole thing was her words. The counterclaim statements were Mr. Waldman's quotes in another article that we don't believe, that's not in evidence. So there's no point arguing about that other than you just have these one or two sentences from Mr. Waldman. So we believe that the jury's going to be confused if we give their instruction and say we cannot read it as a whole, so therefore we can't, follow the jury instruction.
Okay. I can see your point with that. Yes, sir.
I don't think there's anything there's a lot of instructions here. I don't think there's anything that would indicate they can't find a liability if they're not able to take statements in their proper context, in the context of the entire article. Just thought it would be more appropriately phrased to be mutual, as opposed to obviously applying only to one party.
Well, because yours says you must read the statements, which is true, but you also can take the content in the context as a whole. But you can take the context of the op-ed as a whole, which is accurate. What I could do, if you want, I could keep the op-ed up top for their claim, and then for your claim, we can, in determining whether any of the statements attributed to Mr. Waldman are false and defamatory, you must read the statements. I could keep that in there as the second paragraph. That way they can't just pull out, because it's accurate law also, that they just can't pull out the word hoax and say, okay, this whole statement.
Agreed.
Okay?
That's fine. Thanks.
Is that okay?
That's fine in concept. I guess I would ask if Your Honor does that to add a clause saying disregarding any redactions on.
Well, it says the statements themselves, statements in statements, in theirs you must read the statements in context as a whole.
Right. So I think, I mean, could we say in determining whether any of Mr. Waldman's statements or whatever are false and defamatory, you must read the text of those statements as a whole? Text of those statements in context as a whole or something.
Well, it's kind of, you must read the statement in context as a whole.
You must read, can we say you must read those statements in context as a whole?
You must read those
because I just don't want
statements in
them to
context.
think that it's impossible for them to.
Any problem with just putting those instead of the?
I don't think we have a problem with that, Your Honor.
Okay. In determining whether any of the statements attributed to Mr. Waldman are false and defamatory, you must read those statements in context as a whole. This means you may not seize on any one word, phrase, or image, or consider only one particular statement, phrase, or passage in isolation. Does that sound correct?
Yes.
All right, we'll add that as a second paragraph. Keep Sammy busy. All right. Takes care of that. All right, the next one I have is the objections and assertions of privilege.
Which? 32.
Oh, I'm sorry, it's Depp 32.
Okay.
It's a new instruction.
Yeah, right. This is the one at the end. This is the new one.
Do you have the objection?
We do. Yeah.
Okay.
The objection, Your Honor, is that the objections made by counsel during the course of trial, we have no problem with something on that. But instructions, what they're trying to do is to direct the jury what inference to draw from Mr. Waldman's instructions not to answer.
Well, the only legal inference they can draw, they can't draw any inferences from that.
Exactly, and that's my point.
Well, that's what this says. You may not draw any inferences from the fact that objection was made.
Yeah, but saying sometimes attorneys stated objections during the course of this trial and instructed a witness and instructed a witness not to answer a question. Objections and instructions to witnesses are not evidence, and you may not consider them in reaching your verdict, nor are you to draw any. So, why do they need to be told this? I mean, I think this risks confusing the jury.
Because to be fair, in the depositions you wanted to keep in all those objections. When we usually we take them out, but you wanted to keep them in. So I want to make sure the jury doesn't have any improper inferences from leaving those objections in. You wanted to leave them in to show that, hey, I asked the questions, they weren't answered, fine. But you can't infer from that, oh, well, they're hiding something then, or it's attorney-client.
Understood. I mean, just like you can't infer when someone takes the fifth in a criminal case. I get that.
Right, which I would give an instruction for.
Of course, I know. I understand that. But I think that the jury is entitled to draw their own conclusions and not inferences. They're not entitled to infer anything from that. But I just think that this risks confusing the jury and getting the jury to think, if they stand up in closing and say they haven't presented any evidence that Mr. Waldman was doing this, then that's using this instruction as a sword. If they get up there and say they haven't, do you understand what I'm saying? They haven't proven that Mr. Waldman was acting as his attorney. They haven't proven that Mr. Waldman was authorized to make the statements. Then they rely on this to hide behind that. And we're not allowed, and I'm not saying that we will, but I'm not going to say, you heard him instruct him not to answer, and you should infer that he was acting as his agent. I know I'm not going to say that, but if they're going to argue in closing the converse of that, then that's prejudicial, and makes this inappropriate.
All right. Yes, sir. Mr.
Your
Ramos.
Honor, this is just an accurate statement of law. They chose to play about 30 minutes of Mr. Waldman being instructed not to answer. Without this instruction, that's prejudicial.
All right.
And it would also be prejudicial if they're allowed in closing to say that we haven't presented evidence of anything about the parameters of Mr. Waldman and Depp's relationship.
That doesn't follow from this instruction. This instruction is simply saying that the jury is not to draw any inferences from the objections and instructions inserted by counsel. They can consider the evidence. They can consider whether evidence was presented or not. The instructions and objections are irrelevant to that question.
No.
All right. I understand your objections, but it is an accurate phrasing of the law, and I want to make sure that the inferences aren't taken against an attorney-client privilege.
Okay. Can you deny it over our objection?
You got it. No, I can grant it over your objection.
Sorry.
Freudian slip.
I meant grants. Yes, sorry. Okay. Can we get some direction for the arguments that they're allowed to make on closing on that, Your Honor? Because I don't think that's appropriate for them to point to a lack of evidence when they didn't allow Mr. Waldman to testify.
Pointing out that instructions are not evidence is not the same. There's no connection here between these issues, Your Honor.
No, I'm not going to do that. So we're going to do Depp 32. I just need to clean up the top part of it. Okay. All right. Over objection. Be offered. All right. Then I have instruction JJ, which is the model.
Right.
So why would I not give the model?
We believe you should. I think the only looks like the only substantial difference is that they, rather than saying as it's written, it says clear and convincing evidence that Mr. Waldman's statements. It's confusing and misleading to say that if you have found by clear and convincing evidence that Mr. Waldman's statements were made by Mr. Depp, that we already have a principal agent instruction.
Right. If they find principal or agent, I mean, that would be the only basis for it.
Well, first of all, Your Honor, if liability is entirely vicarious, which I think is the position of the counterclaim plaintiff in this case, I don't think there's any evidence of direct liability. If liability is entirely vicarious, then I don't think there's a basis for a punitive damages instruction at all against Mr. Depp, because vicarious liability generally doesn't result in punitive damages as to the principal. Punitive damages are only applied where the person against which punitive damages are being assessed actually engaged in conduct that it was wrongful, and that's not the way they've pled and sought to prove their case. I think that's the first.
So they're correct. Okay, they're saying you're not entitled to a punitive damages instruction.
Well, I disagree with that, and there's no case law that they've cited in here on that, and I think that's going backwards. That's an argument that we are, and I just think that Mr. Waldman's statements were made by Mr. Depp. I mean, I'd be okay with something that said that Mr. Waldman, while acting as an agent for Mr. Depp, made statements with knowledge. I'd be okay with that.
Is that okay?
I think we would maintain our objection on that. On the basis previously asserted, Your Honor, and then what's the other? I'm sorry, could I have counsel's language again one more time?
Sure.
Yeah, if you have found by clear and convincing evidence that Mr. Waldman, while acting as an agent for Mr. Depp, made the statements with knowledge that they were false or so recklessly, I think it's so reckless. There's a typo there, sorry. We'd be okay with that.
Yeah, I mean, we do maintain the same objection, Your Honor, that principal liability, and we do have case law for that proposition.
I'll overrule that objection. We'll go ahead and, can you type that up real quick for me?
Sure.
And get that to me. If you email it to Sammy, we can print it out.
Yep.
Okay, you're in charge of that one. Okay. All right. That's fine. I think that was it, correct, as far as...
I think it was, other than the verdict form.
Perfect. Let's go to the verdict form. Look at this. Do you have the other ones for me yet, Sammy?
I'm typing it out.
If you can print those out.
Yeah.
All right, let me get the verdict form. All right, I think with the verdict form, it was just the first page. Am I correct with that?
In the punitive damages.
And the punitive damage, you didn't have a response, right? Do we have?
Okay. I think there was a comment in what we got from them that we changed.
Okay. All right. Well, in the here. Oh, thank you. All right. I think it was in 1A, the statement was about Mr. Depp. I think the plaintiff wanted that out because we already have the statement has a defamatory implication about Mr. Depp, and the defamatory implication was designed and intended by Ms. Heard, which I think is...
If you look at the, I think it should track the finding instruction, which is jury instruction C on page 4 of the jury instructions, and that's what the verdict form does.
Okay, let me take a look. And that was C? Okay.
Yeah.
Okay.
So the way it's been written tracks the
All
finding
right,
instruction.
tracks the finding instruction.
Yeah, we don't have a strong objection here, Your Honor. I thought it was maybe cumulative, but...
It does match the finding instruction, which would be clear to the jury, so we'll keep that in.
That's fine.
And then the punitive...
And so that would carry through to all of the...
Oh, you withdrew all those?
Yeah. We'll withdraw that, Your Honor. Their proposed language is fine.
All right, so the verdict forms as written are the verdict forms good to go, correct?
I'm sorry, did they withdraw the punitive damages? Okay.
So we're good with the verdict forms. What I have is the verdict forms, correct?
Your Honor, I think yes, but I do just want to make sure, and I understand we don't go back, but I just want to make sure that, for the record, we do maintain that the verdict form should state that the defamatory implication was false and not that the statement was false, because under the Pendleton case, that can, a facially true statement can still have a false defamatory implication.
And I think we had that on the record on Friday, but thanks for putting it again. It's fine. All right, so verdict forms are good. So we'll keep the verdict forms. Did you print out the other? No, you can print it out. That's how, yeah. So which ones are we missing then? We're missing which jury instructions? You're working on 2 of them, right?
32. I have 32 in FF right now.
32 in FF. And you have 1 jury instruction for me, right?
Yes, they're editing it right now. It's JJ.
Okay, JJ is coming in. And did you do the other one yet or no? Here, I got that one. Here, could you guys do Michelle, or could you, on Depp 32, could you take off disputed and send that to us too?
Yes.
Thank you. And that would just leave us, we'll get those 2 printed out, and then I'll tell you the order that I'm going to do them. While I'm doing that, I do have the laptop, if both sides would like to look at the jury evidence on these. We'll stay up here at the bench, but all we did was we put 2 files on here. There's no password for it. As soon as you open up, it doesn't have any internet, and there's just 2 files. One's plaintiff, one's defendant. They just click on those 2, and then they can watch all the audio and the video, okay? So if you want to take a look and make sure, it's been downloaded to everything that we put on our website, which is all the evidence. We didn't receive any new evidence today for audio or video files, so that it's everything on there. But if you want to take a look and make sure that everything is there, you can do that. Also, all the tangible exhibits JB will have, except we need to get those other ones. So you have them? Perfect.
Yes, if I may approach, I have 1301.
Okay.
And then, Your Honor, I just would like some clarification.
Sure.
I understand that Defendant's Exhibit 712 and Defendant's Exhibit 713 were initially moved into evidence in redacted format.
Correct.
Today, we offered them and put them in an unredacted form, so that's the
712A and
713A.
Yeah.
I believe Your Honor should already have those in unredacted form. I believe that's how they were provided to you all.
Oh, they're in our binders down here?
I believe so. I will. Yes, so I believe those you should actually have those in unredacted form from defendants.
All right, defendants. We have a few binders down here. Hold on.
Yes, I think they would be in the binders. That's correct.
712 and 713. All right, we'll take a look at those. Yes.
So I can give you
proffer for the ones that?
Do you want to go ahead and make a proffer now?
Yeah, but it included 712 and 713, so I could give you copies of that.
Oh, you can? Well, that would make Jamie happy since she's down here digging through binders.
Right. So I can give you copies of that right now.
Okay, perfect. All right, now we have those in evidence. Okay, so are we missing any more from over here? Or did you find out about the one that you thought was in evidence?
So, Your Honor, defendant, I believe, it's Plaintiff's Exhibit 120D. I believe actually Sammy and I had a number of back and forths about this exhibit. I believe that defendant's counsel provided a redacted version of that exhibit to the court, but based off of our reading of the transcript, that exhibit was not actually offered into evidence.
Okay, so it's not in evidence then?
It's not in evidence, Your Honor. I thought, and I believe I emailed it to Sammy last week.
You've got to take disputed off.
If you don't have it, I'm happy to bring it tomorrow, but it's not in evidence, so I wouldn't go back and distribute it.
Okay, all right. So I just want to make sure, because it was checked off on somebody's list that it was in evidence, and I just wanted to make sure. I don't know, but it's not. We're good.
And then I heard the exhibits 711A and B. I'm not sure.
No, I think
Is that
711 was
an
wrong.
error?
It was 712 and 713. So we're good.
All right.
So Jamie, are we missing anything else? Sammy, did you print out the ones that they sent you to? The email? Did you email Sammy the?
He's just double checking right now.
Oh, okay. We'll get that in a second. Let me just put these in the order. Get that one without dispute on it. Okay, sure.
DD.
Republication.
Do you still want this last paragraph? To go across down where you get it.
It wasn't in the one that I gave you.
You didn't cross.
Let me see. Yeah, that stays in. Yeah, that stays in. You want to go and print that out? Yeah. All right. Just print out 2 copies so we can share them. The one that Sammy printed off on republication, I'm just going to give you a copy so make sure they're right, okay?
Yes. And you should be receiving your email soon, FF, JJ, and 32.
Okay. So if you print those out too, Sammy. Let's print those out. So you're sending FF also? Mm-hmm. Okay. Did you take the disputed off the top? Thank you. All right, let me just get this printed. could you print me out another one of AA? There's a mark on this one. Or at least email that one to Sammy. Something in the paper, and it just doesn't look right. Got it? Printing? Printing?
I'm not.
Huh?
I'm not.
I'm sorry, I can't hear you.
I'm not connected to this one.
Can you send them to Jamie so she can print them out?
Your Honor, will we be getting just a paper printout or an electronic copy from the court?
All I have is a paper print.
Okay, so we can scan it.
You can scan
okay,
it.
That's fine.
If you want to do it electronic, that's fine.
And then will these be posted on the?
Not until after I get
Not till
them.
after. Okay, wasn't sure. And then they're read before closing.
They're read
so-
before closing. All right. So we have
Thank you.
that.
Okay, so I guess we just replace.
Thank you.
Oh, okay.
If you want to take a look at that instruction and make sure it looks okay before I add it to the stack. Do you have the actual malice one? Was that sent to you? Michelle, you sent the actual malice one?
Yes.
Okay. Oh, never mind. Jamie already gave it. Sorry, Jamie.
And Your Honor, was it?
Is there?
No, I think it's fine. Does the court want to leave the Herd C, Depp 7
No.
sort of things in there? Because otherwise we could.
Oh no. Well, yeah. The numbers at top can stay. I just
Okay.
don't want to say disputed.
No, I don't think any of them say disputed.
Okay. No, the numbers, I tell the jurors to disregard the numbers and the heading. That's better for the record if we keep it that way. Okay, so are you still reading the publication? Okay.
Your Honor, can we get, sorry to bother Sammy, could we get one more printout of the actual malice instruction?
Sure.
Thank you.
Jamie, can we get another actual malice?
AA. So these are only copies.
All right, any objection to the republication then? As typed?
No, Your Honor.
Okay. Put that in there as well.
Hold on.
Is there a typo?
Nope. It's okay.
It's okay?
Yep.
All right.
Your Honor, I just have a very quick question regarding closing arguments, if we may. Does the court have any objection to us playing very small clips of...
As long as they're in evidence, you can play anything, show any picture.
Well, that's my question. So obviously depositions were by video, many witnesses, especially from Ms. Heard. Do you have any objection to us playing video depositions, portions of...
If it's not in evidence, it doesn't get...
No, of course, just what's in evidence.
There's no video depositions in evidence.
Oh, I see what you mean. Okay, so...
The only thing that can be played to them is what is in evidence.
But their testimony, it's witness testimony.
Well, yeah, but depositions are witness testimony that you have during trial. That doesn't go back to the jury as evidence. And video depositions are the same. That would give more weight to video depositions than witness testimony.
So my question is a follow-up question to that. Obviously, this trial was televised, so there are videos of witnesses testifying.
No, none of that comes in.
Okay.
No, the four walls of this courtroom is what the jury decides this case in.
Okay.
Period.
And just so we don't have a problem tomorrow, also, we can't put in front of the jury written deposition or trial testimony.
That's correct.
Understood.
Only things that are in evidence.
Understood,
But you
Your
can
Honor.
show pictures in evidence, you can show video that's in evidence.
Or audio that's in
Or
evidence.
audio that's in evidence. All of that's fair game.
But
You
no display of written transcripts either.
No written transcripts, just only items in evidence. And
No, I'm on the same page.
okay, all right, just want to make sure.
Thank you, Your Honor, for
you
that
have-
clarification.
And you have 2 hours, right?
Right,
2 hours each, and you 2 people over here and 2 people over there. Is that what's going to happen?
Yes, Your Honor, we're going to split our closing, and then only one of us will do the rebuttal.
Okay, and that has to just be on the rebuttal case, correct?
Right.
We have that down, right? We've gone
Understood.
through that a few times.
Understood.
Mr. Chu, do you have something on that?
Yes, I just wanted to make sure we were all on the same page. So plaintiff goes first.
Correct.
Then the defendant, counterclaim plaintiff.
Right. They do
Then-
their defense to your claim, and also they do their offense to their claim.
And then plaintiff.
Plaintiff gets to do their defense to their
And they
claim and
respond
rebuttal.
only with respect to the
Rebuttal.
To the
their
rebuttal.
rebuttal to their counterclaim.
To the counterclaim.
Only.
And so it goes 1-2, 1-2, and plaintiff gets 2 hours, they get 2 hours.
Total.
Is it fine if it's not exactly 1 hour
Oh,
for each?
that doesn't
That's
matter
up
to
to
me.
us.
No,
Okay,
as
thank
long
you,
as your
Ron.
time is just 2 hours, it doesn't matter how much anybody does.
Thank you, Ron.
Okay.
If you wanted to shorten that to about 15 minutes apiece.
I would want to shorten it to 2 minutes, but that's not my take. I gave you 2 hours. I thought
we
that was
got
good.
pretty efficient at the end of this
Well,
case.
it's amazing how that happens. It's kind of like the physics. You make a circle, and if the people will fill that circle. Well, that's what happens. I made a circle. Okay, so let's go ahead. Let me just go ahead and read into the record the order that I'm going to give the jury instructions. I'll also read in the record the instructions that were denied. And I will read the instructions that were withdrawn, just so we have a complete record, okay? All right, here we go. All right, so for the jury instructions, I'll read them in the following order. Number heard I, number 3, number 10, 1, B as in boy, C as in Charlie, D as in Delta, E as in Echo, F, G, H, 12, 13, Y, FF, AA, BB, DD, that's David, DD, TT, CCC, 20, Z as in zebra, T, U, V as in Victor, K, L, 5, 6, 7, 32, 8, 9, 16, I, 30, KK, and JJ. All right, those are the ones that will be read to the jury in that order. Okay. The ones that were denied was instruction 22, 23, 24, CC, NN, both as in Nancy, OO, PP, RR, SS, S as in Sam, SS, 28 and 29 were the ones that were denied. The ones that were withdrawn, for the record, was instruction A, 2, 4, 11, 14, 15, 17, 19, 21, 25, 26, 27, X as an X-ray, 31, W, EE, GG, QQ, DDD, Q, 18, J, M, N, O, P, R, S, HH, LL, UU, VV, WW, XX, YY, ZZ, AAA, and BBB. All right. So I will get you copies now. I'll get you hand copies of the jury instructions I'm going to read in that order, so you'll have copies when you leave here, okay? And I'll give you copies of the verdict form as well. And you can have those while you prepare for your closing arguments. Other than that, if you could come up to see Jamie after I leave the bench just to make sure you go through the exhibits and everybody okays the exhibits, so we don't have to do that tomorrow. And also if you can have a look at the laptop with Sammy just to make sure all your exhibits are there that are going to go back to the jury, okay?
Your Honor, one quick question
Okay.
about closing to make sure
Sure.
we don't have any issues tomorrow. Understand the jury only sees evidence
Yes.
that they've seen in the trial. If that evidence is displayed through like a PowerPoint or whatever, are headings allowed, or do you not want the jury to see any written text or anything other than just evidence?
I mean, I've seen PowerPoints in cases before in med-mals where they have their other items up there, but I think in this particular case, I'd rather just have no writing and just have your arguments orally.
That's fine. I just wanted to, make
Okay.
sure that there wasn't
Just try to keep it clean.
or paraphrasing of witnesses or anything like
Okay.
that. It's just
That sounds fine with everybody. Does anybody?
That's fine with me.
That's a good question, though. Are you going to have a PowerPoint?
Probably with evidence.
Okay.
You know.
Did you want me to have the big screen up as well for the PowerPoint?
I think so. Yeah, I think that would be great.
Thank you,
Okay.
Your Honor. Yes.
Okay,
Thank
good.
you.
We'll do that as well.
And starts at 9.
Starts at 9. Closings start at 9.
So, Your Honor, Mr. Nadelhaft has a proffer still on some things.
Oh, yes, okay.
Do you want to do that now? Before we...
Sure.
As does Ms.
Everybody
Myers.
wants to hear your preference.
As does Ms. Myers at the end of Mr. Nadelhoff's.
Yeah, okay. All right, they have one too. So, that's all right. Go ahead.
Yeah. This'll
If you could just get to the microphone so I can hear you better. Or the court reporter can hear you better.
This will be shorter than the other day.
Oh, good.
Okay. This is for metadata. On May 16th and May 17th, 2022, the defendant attempted to introduce into evidence photographs from May 21st, 2016 that included metadata on the photographs. Ms. Heard testified that the metadata was included on the photos by pressing a button on her phone. The metadata demonstrated the pictures were taken on May 21st, 2016, along with the times they were taken. The exhibits were defendant's exhibits 700 through 726 and are exhibits A through AA of the proffer. Tabs N and O of the proffer are now blank, as defendants 712 and 713 were admitted with the metadata on May 26, 2022. Mr. Depp objected to the metadata on the document, stating that the metadata was hearsay and there was no foundation for the hearsay. The court sustained the objection on the ground that the metadata was hearsay and that there was no foundation, and admitted the exhibits but redacted the metadata. And then separately, we have a proffer for Stephen Deuters. On May 20th, 2022, Ms. Heard moved to designate certain portions of the deposition testimony for trial of Stephen Deuters, who was Mr. Depp's personal assistant. Mr. Deuters testified that he was on the Boston flight and sat in a seat facing Ms. Heard and Mr. Depp. He further testified that the day after the flight, Mr. Depp told him he wanted to, quote, smooth whatever issue, end quote, existed with Ms. Heard. Mr. Depp asked Mr. Deuters to, quote, write a text, end quote, to Ms. Heard and to say, quote, whatever she needs to hear, end quote. Mr. Deuters then sent a text message to Ms. Heard about Mr. Depp, stating, quote, when I told him he kicked you, he cried, end quote. The testimony is contained in Exhibit A, Mr. Deuters' deposition. Ms. Heard moved to admit the text message into evidence, arguing it was not hearsay under Rule 2:803, which provides for the admission of statements of a party opponent and his agents. Ms. Heard argued Mr. Deuters was acting as Mr. Depp's agent when he sent the text, and the text message was therefore not hearsay. The text message is Exhibit B to the proffer. Mr. Depp objected to the text message as hearsay, arguing that although Mr. Deuters was Mr. Depp's employee, sending text messages to Ms. Heard was not within the scope of the employment. The court denied the motion to admit the text message in testimony, finding that Mr. Deuters was not acting as Mr. Depp's agent when he sent the text message. And I have copies to provide.
All right, fine. We can add it to
The list. Yeah.
We have a box for you. All right, we will
Here's this.
add that.
Oh, sorry, Eric.
I think he has more.
And this is the other one.
All right, we'll make them part of the record. Thank you, sir. All right, yes, Ms. Myers?
Thank you, Your Honor. On May 25th, 2022, plaintiff intended to call Dr. Kim Collins as an expert witness in forensics pathology. Defendants objected on the basis that Dr. Collins had not been designated as a defensive witness and was designated only to rebut Dr. Jordan, which was defendant's forensic pathologist who had not been put up at this trial. Dr. Collins intended to testify as to whether Ms. Heard's descriptions of violence and injuries allegedly sustained by Mr. Depp were consistent with the photographic evidence at issue in this trial. She also, for incidents where there was no photographic evidence, she would have testified as to what injuries she would have expected to see based off of the violence that Ms. Heard testified to. And finally, she would have testified as to her opinion as to the cause, or as to Mr. Depp's finger injury and what she observed, consistent, which was similar to what Dr. Gilbert testified to today.
All right, thank you. Any other proffers? Okay. All right, so just don't leave here until you check the laptop and you check all your evidence and make sure we get your checkbox on that and everybody's happy with it, okay? Anything else for the court?
Thank you.
Really?
No, thank you.
Thank you very much.
Thank you. Okay.
Thank you, Your Honor.
We'll see you in the morning.
All right.
Stone. I'm Michelle Yu, and welcome to the third hour of For the Record here on Law and Crime. Thanks so much for joining us. Earlier, Judge Ascarati dismissed the jury for the rest of the day in the Johnny Depp versus Amber Heard defamation trial. The jury will return tomorrow at 9 a.m. Eastern Time for closing arguments. Before we break down that star-studded case, I want to remind you of the other case we are covering down in Florida. Today marks day 7 in the retrial of defendant Catherine Magbanua. The state rested yesterday, so today the defense began to present evidence to the jury to prove she is not guilty of a first-degree murder, conspiracy, and solicitation to commit murder of FSU law professor Dan Markel back in 2014. If you want to check this trial out, you can also watch it on our YouTube channel. And now, though, circling back to Fairfax, Virginia, both sides have rested in day 23 of the civil defamation trial of Johnny Depp versus has allowed 2 hours for each side, and after she reads the jury their final instructions, the case will then be handed over to them to deliberate. Now, Law and Crime is all over this case, as you know, in Fairfax, Virginia, so tune in tomorrow and we'll keep you up to speed with any movement in that courtroom while we are near the end of this star-studded trial and begin verdict watch. Now, since court is in recess, let's recap some of the rebuttal testimony of the forensic psychologists called in this trial, each presenting very different perspectives about Heard and PTSD. Let's take a look at Dr. Shannon Curry's testimony first. She was hired by Depp's team.
All right. Dr. Hughes says that Ms. Heard has PTSD. Do you agree?
I do not.
Why not?
The results of my multi-method comprehensive evaluation based on carefully selected, researched, relevant test instruments, based on comparing those instruments to Ms. Heard's self-report, observing Ms. Heard's behavior over 12 direct hours of assessment, reviewing copious notes from prior therapists who indicated symptoms in their notes, reviewing the notes of Nurse Filati, previously Nurse Borum, who spent, I believe at one point, almost 2 months with Ms. Heard daily, reviewing the notes of her treating providers, all of the legal documents and discovery. There was no evidence of PTSD.
How is evidence of PTSD generally exhibited?
So really the bottom line in a forensic psychological evaluation is a change in functioning. That's what we're looking for. Again, I said we don't have a crystal ball. We're not wizards. We can't get into somebody's head. What we're looking for were there identifiable changes in the way the person engaged in their world. Were they able to keep a job? PTSD is an extremely disabling diagnosis. When a person has true PTSD, it is difficult for them to work. You'll see unemployment, job loss. It causes extreme levels of distress and impairment. There's divorce, there's isolation and estrangement from children, from family members, extreme alcohol abuse, often a string of sudden DUIs when the person never had any before. They become homebound, they can't go to the store. They're certainly not going to events. They're not having success in their film career, usually. They're not exercising every day, pursuing their hobbies, being avid readers, obtaining level 3 sommelier training, having dinner parties with friends, speaking to public groups. Those are just indications of very high functioning. And when you're looking for a decrease in functioning over time, that is inconsistent with that decrease.
All right, with that in mind now, let's compare Dr. Curry's testimony against what Dr. Dawn Hughes said when she returned to the stand to testify in Amber Heard's rebuttal case earlier this morning.
Dr. Hughes, Dr. Curry also testified that a victim of PTSD has to effectively be prone and unable to function at all. Would you agree with that?
Objection misstates the evidence.
She said they couldn't hike, they couldn't move, they couldn't function in any way, shape, or form.
Objection.
Thank you. No, that is not correct. That is often actually a myth and misconception about individuals who are struggling with PTSD or trauma-based disorders, and I'm often called to answer that and speak to that. People who are struggling with trauma and PTSD are very strong, courageous, resilient people, even though that they're struggling. They get up, they have to go to work and drop their kid off at school and go to the market, even though they're struggling with these symptoms. So I often talk about it as this sort of walking around with a 50-pound bag of flour on their backs, just sort of trying to get through the day, where sometimes that button's going to press play and the trauma's going to start activating in their head, and then they're going to be having to think about it and have startle and have physiological reactions until they can find a way to hit that pause and shut it off again. So they still have, impairments in other ways, but they go about their lives. They're not, totally debilitated. If you have someone in that high range, the highest score is an 80 on the CAPS, Ms. Hurd had a 28. If you have someone in the higher range, we have seen people who are, severely disabled because of it, but that's not the norm of people who have this moderate PTSD. And did you find functional impairment with Amber?
Yes, I did.
Now, Dr. Curry also said that it is not within the scope of a psychologist to evaluate domestic violence. Do you agree with that?
Of course I don't agree with that. This is what I do for a living, day in, day out, for 25 years. We are specifically trained to understand the profound impact that trauma has on people's lives. That's what we do in the trauma division of the American Psychological Association. We disseminate that knowledge. And domestic violence is one of those profound traumas. Domestic violence is part of state licensing boards, that you can't get licensed in some states unless you take training on domestic violence. You can't renew your license unless you get training on domestic violence. So people who have, specialized training in this area, it is, beholden upon them to accurately assess for intimate partner violence and sexual violence. And it's more important to assess for this sort of scientific understanding of what domestic violence is. So you have to assess for the physical violence, the psychological violence, the surveillance, the economic, the emotional abuse, and the sexual violence. That is not gratuitous. That is understanding.
Narrative. All right. Next question.
And I want to bring in my guest this hour to discuss that testimony. Sticking with us here is crime analyst Lisa Lockwood, and we also have psychiatrist for Women's Health, Dr. Yalda Safai, joining us too. Yalda, let's start with you. Do you think Dr. Hughes did well here? She pointed out that in contrast to what Dr. Curry said, those with PTSD can function in society.
Of course. In fact, they function for years before they even recognize they have PTSD, before they even recognize it and seek treatment for it. So it's very much possible for someone to have something called high functioning PTSD. So yes, it's possible.
Lisa, both doctors did not evaluate Amber Heard in the same way. So are different approaches fine? Do you have to nitpick rules and regulations about psychological tests?
Well, I think the guest you have right now would be better equipped to answer that question because she's probably done that. So there are an array of ways of coming up with a diagnosis, and both of them talked about their methods and what they use. Some of them were similar, and then some went beyond the other person's method. But what I do find interesting about PTSD and what we're discovering right now is it's on a scale. Can it be completely debilitating? Are you depressed? Do you have a complete change in your function? Or do you show up courageous, resilient, as Amber Heard's doctor had said? So knowing that there's a scale, I thought that there was a scale with depression, and knowing people in the military and police and people who have had incidents in their life and veterans that suffer through PTSD, a lot of them, I guess, are higher on the scale because they do turn to drugs. They do end up changing their complete function. They're not able to work. And these are the only PTSD victims that I have had to deal with, and knowing that they fit that criteria. So this is new information for me.
And Yalda, so I want to get your take on that because obviously you're the professional here.
Right. So I agree with what she said about being there is spectrum for PTSD. You can have mild symptoms and you can have severe debilitating symptoms. And sometimes it's a progressive thing. You might start out with mild symptoms that just become more and more debilitating. And it's only when you have those debilitating symptoms that you seek out help and treatment. Now, in terms of approaches to treating PTSD or diagnosing PTSD, yes, there's a general guideline that meets the criteria for PTSD. And it's really, every psychologist and psychiatrist has different ways of exploring this to determine whether someone really has PTSD or not. There's no blood test to say you definitely have PTSD or not. It's very subjective. So people have different methods and different ways to come to the conclusion that a person has PTSD. There is a diagnostic criteria we follow, but every psychologist or psychiatrist has their own way of coming up with an answer.
Now, we can't forget to discuss testimony of psychiatrist Dr. David Spiegel. During cross-examination on the stand, he made reference to the Goldwater rule when asked if he examined Johnny Depp. Let's listen and discuss on the other side.
You were asked about whether you were able to examine Mr. Depp. Do you recall those questions back and forth?
Yes.
And so if I understand your testimony, you asked twice for Mr. Depp to be interviewed by you, correct?
Yes. Objection leading.
And overruled. And then in addition to that, Ms. Heard requested twice of the court for Mr. Depp to be submitting to an examination of you, correct?
Yes.
And those were denied, correct?
Yes.
And now Mr. Depp is contending that it's unethical for you to provide an opinion in this case because you didn't get an opportunity to interview him. Do you think that makes sense?
Objection, Your Honor.
I'll sustain the objection.
All right. Is that your understanding?
That is my understanding of it.
Okay. Now, when counsel for Mr. Depp was reading to you the Goldwater rule, there were two words that he kind of went over pretty quickly, and I'm going to go over them again with you a little bit slower. And that was that the Goldwater rule was that you cannot make an armchair diagnosis, right?
Objection.
Based on, quote, publicly available records. Do you recall that?
Yes.
Okay. Now, the records that you reviewed in this case were private, were they not?
Yes.
And in fact, Dr. Blaustein's records were marked confidential, correct?
Yes.
And his deposition was marked confidential?
Yes.
Okay. And Dr. Kipper's records were all marked confidential?
Yes. Objection leading.
I'll sustain.
Okay. What, if any, labeling was there on Dr. Kipper's deposition?
All the documents I reviewed were confidential, and I also signed the confidentiality agreement, so everything I looked at was confidential.
Okay. So that, in fact, does not even comport, that doesn't meet the restrictions that were put.
Objection leading.
I mean, so would it be fair to say that you have not, or have you rendered any opinions in this case as an expert witness based on publicly available records?
I have not rendered any opinion based on any publicly available records.
Dr. Yelda Safai, what could you tell us about the Goldwater rule here? How much weight should the jury take in Dr. Spiegel's testimony?
Very much. It's very unethical and forbidden. It's very unethical and forbidden for a psychiatrist to pass comments or make a diagnosis without evaluating a patient, specifically if that is a public figure. So I am completely in agreement with the psychiatrist that he avoided answering this because, like he said, the Goldwater rule states that we are not allowed to pass a diagnosis or comment on the mental state of anybody, especially a celebrity, without evaluating them ourselves.
Let's not forget Dr. David Spiegel had quite the circus testimony as well when he took the stand. All right, we're going to take a quick break here on Law and Crime. When we come back, so much more to cover on day 23 of Johnny Depp versus Amber Heard. Stay with us. We'll be right back.